Welcome back to Organize, the Business Law Breakdown. I'm your host, Seth C. Oranburg, and today we're delving into one of the most important yet sometimes overlooked aspect of contract law, conditions. Unlike promises, conditions are events or circumstances that must occur before a promise must or must not be performed. You can't breach a condition like you can breach a promise. But when conditions aren't met, it affects whether a party is required to fulfill their contractual obligations. Today's episode will center around cases that illustrate how conditions, not promises, determine whether obligations exist. And we'll look in particular at conditions of satisfaction, which operate based on subjective or objective standards. But before we dive deeper, here are 3 key takeaways to keep in mind for today's episode. You'll learn how conditions control whether an obligation to perform a promise exists, and why conditions themselves can't be breached. You'll understand how these 2 types of conditions precedent and conditions subsequent, either trigger or extinguish obligations in contracts, and we'll contrast both to conditions concurrent. And finally, we'll look at conditions of satisfaction. We'll explore how subjective and objective standards of satisfaction affect when performance under a contract is deemed acceptable. So, by the end of this episode, you'll have a better grasp on how conditions operate as the critical switches in contracts, determining when duties are owed and when performance can be excused. Now let's dive in, and let's start with an overview of the core concept of condition and how that determines whether contractual obligations exist. At its heart, a condition is an event that either triggers or extinguishes an obligation to perform under a contract. It's a key concept that can make or break a contract, and it's not the same as a promise, because there's no contract liability for performing or not performing a pure condition. There is, on the other hand, liability for not performing a promise, at least when that promise is obligatory because a condition has occurred. Here's a simple way to think of conditions. Imagine a contract as a wired circuit. The obligation in this picture is the light bulb, and the condition is the switch. The circuit is always there. The contract is always wired, but the switch, whether on or off, decides whether the light is on. Conditions either activate or deactivate a party's duty to perform under a contract. For example, in Morrison v. Baer, we'll see how the court navigates whether a condition has been satisfied and how the non-occurrence of a condition impacts the obligation of the parties. But what's important to remember is this: conditions themselves are not promises. You can't breach a condition. If a condition doesn't occur, it doesn't mean someone broke their promise. It doesn't mean someone breached the contract. It just means that the obligation tied to that condition isn't due, isn't owed. The non-occurrence of the condition is what matters when determining whether or not obligations in a contract have to be performed. There are 2 main types of conditions that we often see: express conditions and implied conditions. Express conditions are explicitly stated by the parties, like, I'll mow your lawn if it doesn't rain on Friday, or I'll mow your lawn on condition that it doesn't rain on Friday. If it rains, the condition wasn't met, and there's no obligation to mow the lawn. On the other hand, implied conditions aren't written out, but are understood as necessary for a contract to function, and we have a lot of these. In particular, that parties' performance are mutually obligatory to each other, meaning if a detailer promises to wash your car, it's implied that you're going to pay. In fact, it's also probably implied that you're going to bring your car to the detailer's shop. Otherwise, how could the service be performed? So we have lots of types of implied conditions, and in fact, most contracts have an implied condition of mutuality. The idea being that I promise to do something for you if you promise to do something for me, and vice versa. Another key concept is a condition of satisfaction, which is a special kind of condition we'll cover in more detail when we look at Morin versus General Motors. These conditions often apply in contracts that hinge on personal or aesthetic satisfaction. The law draws a line between a subjective satisfaction, meaning whether the party is actually satisfied, and objective satisfaction, meaning whether a reasonable person in the position of the party would be satisfied. And the distinction can have huge implications, because a party can try to back out of a deal by claiming that they weren't satisfied, and in general, courts won't let them so long as a reasonable person would be. Finally, there's the doctrine of excuse of conditions, when it comes into play when the strict enforcement of a condition would lead to unfairness. Sometimes courts will excuse the non-occurrence of a condition to avoid inequitable results. So, to summarize, conditions serve as switches that control when contractual obligations turn on or off. But they are not promises themselves, although there is a category called a promissory condition. If a condition doesn't occur, the promise tied to it may never be owed, but the non-occurrence of a pure condition, as opposed to a promissory condition, isn't a breach. Well, let's break it down with the key case, starting with Morrison v. Baer, and we'll try to explicate the meaning of conditions. Morrison v. Baer operates how conditions operate and determines whether contractual duties are owed. In Morrison was to purchase a property from Baer. The agreement, the real estate purchase agreement, included an express condition that required Baer to prove that certain repairs, specifically to the furnace, in particular to the heat exchanger of the furnace, had been completed. This proof of repairs to the heat exchanger is a condition precedent, meaning Morrison's obligation to purchase the house would only kick in and activate if Baer proved that he fixed the furnace. Here's where it gets interesting. When Baer failed to provide the proof, Morrison demanded that Baer sell him the house for the difference between the contract price and the cost to repair the furnace. Baer argued he wasn't obligated to sell the house for less than the purchase price, and the court sided with Baer. Why? Because you can't breach a pure condition. If Baer had made a promise that he'd fix the heat exchanger and he didn't do it, then maybe Morrison could get expectation damages for the value of the repair. But Baer didn't promise to do this. Instead, Morrison promised to buy Baer's house if, or on the condition that, Baer repaired the furnace. So when Baer failed to do the repair, Morrison was not required to buy the house. Morrison could waive the condition and buy Baer's house anyway, pursuant to the terms of the contract, regardless of the non-occurrence of the condition, but Morrison did not have to. Morrison's obligation was not turned on because Baer's promise was not performed. What Morrison wanted was to buy the house for less than the contract price, and that's simply not available here because the non-occurrence of the condition, in this case the failure to provide proof of the furnace repair, only meant Morrison's duty to perform was not triggered. Baer didn't breach the contract. Morrison didn't have to perform it either. Because the condition precedent hadn't been met, Morrison could walk away from the deal, but he couldn't force Baer to conclude the deal for less than the purchase price. This case is a perfect illustration of how simple conditions work as switches in contract law. The obligation to perform only comes into play if the condition is satisfied. If it's not, no breach has occurred and the duty doesn't arise either. The parties can simply walk away. This rule is key for understanding the difference between conditions and promises. Conditions prevent or cause a duty from coming into existence, which is exactly what happened here. The lesson? Always make sure you understand the conditions in your contracts, because the failure to meet them means the contract doesn't need to go forward, although it doesn't bring anyone into breach. Let's explore a what-if scenario that helps us understand the role of conditions in contracts a bit more clearly. What if you enter into a contract to buy a car, but the deal includes a condition that the car must pass a mechanical inspection before you're obligated to complete the purchase? So, you take the car to a mechanic and they find a few small issues. Nothing major, but enough to require some minor repairs. The seller refuses to make the repairs. Do you still have to go through with the purchase? The legal answer in general is no. You don't have to purchase the car, even though the defects are minor, because the technical doctrine is that express conditions, like the ones in this case, must be completely and totally performed before the conditional duty becomes due. In this case, the condition was that it would pass inspection, meaning completely pass inspection. No issues, no repairs required. Even if there are minor issues, minor repairs required, it's still not passing inspection completely. So the condition in this case acts as a condition precedent, and since it's an express condition, it has to be completely performed. Otherwise, and until that condition is completely met, you have no duty to buy the car. So since the car failed the inspection, the condition wasn't satisfied, and you're not obligated to buy it. Importantly, you can't sell the sewer for breach of contract either, because they didn't promise you the car would pass inspection. It was simply a condition for your duty to arise. Now let's flip it. What if the car passes inspection, but you decide you don't want it anymore? Can you still back out, citing the inspection condition as a reason? Well, no. Once the condition is met, now you have a duty to perform. Unless there's another valid reason, you'd be breaching the contract by backing out of the deal. Let's add one more layer. What if the seller agreed to repair the car after it fails the inspection? This could lead to the condition being satisfied after the fact, at which point your duty to purchase might be re-triggered. These scenarios illustrate the pivotal role of conditions in determining whether duties arise or disappear on a contract. Whether you have to perform depends on whether a condition is met or satisfied. Now let's dive into our second case and break it down again with Morin versus General Motors. This case introduces us to a new kind of condition, a special condition called the condition of satisfaction. This case helps us understand how the law distinguishes between a subjective and objective satisfaction when evaluating whether a condition of satisfaction has been met. So here's what happened. General Motors hired Morin Building to construct a building for their plant, and part of the contract included a condition of satisfaction regarding the quality of the work. Specifically, GM reserved the right to reject the work if they weren't satisfied with the visual appearance of some aluminum siding that Morin installed. After the job was completed, GM wasn't happy with the way the siding looked. It wasn't uniform enough for their aesthetic standards. In other words, the old aluminum siding and the new aluminum siding looked slightly distinguishable under certain lighting conditions. And they claimed that the condition of satisfaction had not been met because it was an express condition and they reserved all rights to apply their aesthetic judgment. They refused to pay the balance of the contract. Morin, on the other hand, argued that the work was perfectly functional and would meet a reasonable industry objective standard for commercial construction, so that GM was in breach by refusing to pay. That GM's obligation to pay was triggered because they had done a satisfactory job. So the key issue here is whether GM's dissatisfaction is based on a subjective standard, like what GM personally liked or didn't like, or an objective standard, namely what a reasonable person would consider acceptable under these commercial circumstances. A subjective condition of satisfaction means that the party's personal opinion controls. And this would usually be the case in contracts for very personal services like artwork or certain kinds of custom goods, where personal taste is the key factor. In such cases, if a person isn't actually satisfied, they can withhold performance, even if their dissatisfaction seems unreasonable. An objective condition of satisfaction, on the other hand, applies when the contract requires that performance meets a standard that any reasonable person would accept. This standard is often used in commercial contracts where aesthetic preferences are secondary to functionality. So what happened in this case? In Morin versus General Motors, the court ruled in favor of Morin Building. They found that GM's dissatisfaction was not based on a subjective standard of personal taste, but rather it should be held to an objective standard, measuring the quality of the work against industry norms. This was, in fact, aluminum siding on a factory plant after all, and it was functionally acceptable and would meet reasonable expectations for commercial construction. In fact, the court reasoned it would be virtually impossible without undue expense to make old aluminum siding look like new aluminum siding. GM couldn't refuse payment just because they didn't like the look of it. The case highlights the importance of clarity when drafting conditions of satisfaction. If you're relying on personal preference, it really needs to be very clearly stated as a subjective standard. And even if you try to state it that way, the court might not honor it when it's unreasonable because you're dealing with something commercial. But if performance is to be judged on industry standards or general reasonableness, conditions of satisfaction will be evaluated by an objective standard, meaning what would a person in the industry generally be satisfied with? The lesson from Morin is that standards of satisfaction, whether subjective or objective, must align with the nature of the contract. So if you're working with a condition of satisfaction, be sure to understand which standard applies. It could make all the difference in whether a party can legitimately withhold performance. Let's take a break from legal jargon and look at how conditions of satisfaction show up in pop culture. For today's episode, we're heading to Scranton, Pennsylvania, straight into the chaos of The Office. In one memorable episode, Michael Scott, the quirky and often misguided manager, launches a golden ticket promotion where random customers get a major discount. The idea was supposed to be a fun Willy Wonka-style event, but it backfires when one of Dunder Mifflin's biggest clients gets multiple golden tickets and demands a huge discount, throwing the company into a financial crisis. Well, Michael came up with the idea, but when it fails, as you might know, he tries to blame someone else. So Michael fires Dwight, one of his employees, and then tries to fire others. And he does so based on the claim that his employees did not live up to his own satisfaction. But if we look at this through the lens of commercial contracts and commercial conditions of satisfaction, an objective lens, it's clear that Michael expected the promotion to achieve some unreasonable vision. Although it didn't live up to his personal vision for how successful it would be, that's not what really matters in areas of commerce. In commerce, we should look at whether or not the employees provided some objectively reasonable standard of satisfaction. So even if reality doesn't live up to Michael's standard, he's going to have to accept that responsibility. What's the key takeaway here? In the business world, especially in contracts involving conditions of satisfaction, it's critical to define whether you're operating under a subjective standard, and even if you try to, the court might not let you get away with it, or recognize that you're probably going to be facing an objective standard, where the question is what a reasonable business person would expect from such a promotion. Michael is not the reasonable business person. So just like Michael, if you're setting conditions of satisfaction based on personal preference, you need to be really clear about that up front. Otherwise, you may find yourself in a tough spot when things don't go as you expect. All right, let's recap what we learned today. We took a deep dive into the role of conditions in contracts and looked at how they differ from promises. In Morrison v. Baer, we saw how a condition precedent can turn off obligations if it's not met, highlighting that conditions act like switches in contracts. They determine whether a duty to perform even arises in the first place. We also explored Morin v. General Motors, which illustrated the distinction between subjective and objective standards of satisfaction in contracts. If the parties aren't clear about which standard applies, it can lead to disputes over whether performance is acceptable. And finally, we looked at pop culture from The Office, where Michael Scott's golden ticket idea showed how subjective satisfaction gets messy if expectations aren't clearly set in advance. And it reminded us that, in commercial context, we prefer the objective standard of satisfaction, what the reasonable business person would think. If you enjoyed this episode or learned something new, please share it with your classmates or colleagues. Don't forget to subscribe so you don't miss the next episode. And if you have any questions or feedback, feel free to reach out to me or leave a comment on our platform. Next time, we'll be shifting gears to talk about anticipatory repudiation. That's what happens when one party announces they're not going to perform before their obligations even due. And so that's all for today's episode of Organized, the Business Law Breakdown. I'm Seth C. Oranburg, and I thank you for tuning in and exploring conditions with me today. I hope you found this informative and helpful. And remember, until next time, keep your agreements strong and your arguments stronger.